हमारा that was the last topic in that context of types of partners. The previously we have been talking about holding out partner, any partner who at least showed himself to be a partner. So although he was not a partner, but for legal process and legal matters, we will take him to be partner if Section 28 and its conditions are applicable. यहाँ पे it's a question of minor partner. Can be a minor partner in a firm or not? So आपकी क्या could be the possible answer from you people? Whether a minor, generally under the Contract Act, the general law of contract, it forbids any partner, any minor to enter into a contract. Now, what about that minor partner?
सर जैसे ये कॉन्ट्रैक्ट लॉ में तो सर नहीं हो सकता जनरली के नो माइनर के बी अ पार्टी इन कॉन्ट्रैक्ट। तो सर हम यहाँ पे स्पेशल लॉ को देखेंगे जो कि पार्टनरशिप एक्ट है, तो उसके मुताबिक ये क्या कहता है माइनर के बारे में सर, उसको प्रिफर करेंगे।
ओ यस राइट। तो एक तो ये आपके पास एक
सर
रूल है। जी जी
सर देखा जाए तो नहीं हो सकता, लेकिन ये डिपेंड नहीं करेगा जो दूसरे पार्टनर्स होंगे उनके कंसेंसस पे। लेकिन इसके फिर जो जैसे कि ये उम्र में कम है तो शायद इसको जो बेनिफिट्स वगैरह मिले या जो मतलब वो शेयर्स वगैरह जो होते हैं सर, जो बेनिफिट्स बेसिकली जो इसके शायद वो कम हो। अगर कंसेंसस ऑफ पार्टनर्स है तो शायद हो सकता है मेरे ख्याल से।
So now, being a legal person, being a logical person, if you are giving him less advantages, how would you how would you respond? How would you equate that with some other provisions या with some other conditions? That if on the one hand you are giving him less advantages, why? Okay,
तो
fine.
सर
If
जो
you're
इसकी इस इससे जो सर्विसेज ली जाएंगी सर वो भी तो फिर लिमिटेड होंगी ना,
yes,
क्योंकि
so
ये वो सर्विसेज तो प्रोवाइड नहीं कर पाएगा जो एक मेजर कर पाएगा।
yes, exactly. So we have to be logical always. That if you are putting him at disadvantage, so you have to accommodate him in some other matters. And this is what has happened in Section 30. Simply, you give him some advantages and you give him some more benefits in some respect, but you take from him some benefits, and that's how Section 30 is all about. एंड थोड़ी सी इंटरेस्टिंग चीज़ इसमें जो है वो हम देखते हैं इंशाल्लाह. So generally there is a big no, but since it's a partnership, special law for the partners, तो यहाँ पे special law then will be prevailing on the general law of contract. तो एक तो ये आपने माइंड में रख देना है, one of the examples, general and special law. Civil law में, criminal law में you might be having many examples. Here in the civil law you can have these examples that generally under the general law a minor cannot enter into a contract, so this is a general law. But if anything has been provided by special law, that will prevail. For example, the section 30 would prevail over the general law of the contract. Now, how the section 30 is read as follows: a person who is a minor, according to law to which he is a subject, यानी हर एक minor का जो law है उसके मुताबिक if he is a minor, may not be a partner in a firm, but with the consent of all the partners, number एक, for the time being, जो at that time who are the partners, उन तमाम की consent के साथ, he may be admitted to the benefits of partnership. Second condition, benefit of the partnership. Number one, consent of all the partners. And number two, benefit of all the partners. So that was subsection one. As a consequence, the section itself then lays down certain rights and duties of that minor. कैसे? पहली बात तो ये है कि that would have to be before complying or before admitting any minor or before applying section 30, we have to see the two conditions. Number one, that there was a valid partnership in which all the partners they were doing the business, and the valid partner means section 4 is applicable. They are group of people which are who are together for the purpose of business, etc., etc. One is working on behalf of the other. एजेंसी का उसमें कॉन्सेप्ट एग्जिस्ट कर रहा है. नंबर टू, mutual consent of all the partner to admit him for the benefit of the firm. जैसे as I told you, every partner has to give his consent, and the benefit of the firm has to be in mind of all the partners. So inclusion of minor in a partnership may be mutually beneficial. Now the next question is that how can we say that addition of a minor partner is beneficial for the firm? What are your guesses about that? How could we say, or what could be the possible situation where admission of the minor is the benefit of the firm? What guesses could come into your mind?
सर उसमें लायबिलिटी भी
025 025 041 42. ये नंबर नोट करते जाएं रशीद.
Sure, sir.
43 17.
Sir, 43 मैं हूँ sir.
अच्छा 17.
Yes, sir.
G17. What do you think?
Sir, ये उनको
Could there be a situation where minor is admitted into the firm for the benefit of the firm?
सर ये बंदा इन्वेस्टमेंट लेके आ सकता है और उसके बाद मतलब कोई ऐसी चीज़ नहीं कर सकता जिससे फर्म लायबल हो स्ट्रिक्टली.
So why not? चलिए ठीक है. So we can say that investment is being added into the firm. So in this way, it is for the benefit of the firm. Logical, ठीक है, fine. The next question is, why would a partner be interested to get into the firm or invest into the firm for the benefit of the firm? Why the partner? What should he? What should he be expecting, or why would he be interested to admit himself into the firm? इसको आप किस एंगल से देखें?
सर इस एंगल से एक तो ये हो सकता है कि पार्टनर ये देखेंगे कि उनकी जो उसका जो वो होगा, यानी कि वो इतना वो नहीं करेगा, इंटरफेयर नहीं करेगा कामों में, बस उसका इन्वेस्टमेंट होगा और काम सारा हम ही करना है.
ठीक है, so that is the benefit of the firm. Why would be a partner, a minor, interested to get into the firm?
सर प्रॉफिट
सर
मिलेगा.
जैसे कि उसका वहाँ पे शेयर है तो सर वो जो भी है उसको प्रॉफिट्स वगैरह वो भी मिलेंगे सर. जो इन्वेस्ट करेगा तो ऑब्वियसली सर जो भी प्रॉफिट होगा इक्वली शेयर होगा अमंग पार्टनर्स.
सर वो ये भी हो सकता है ना कि वो भी ये वो करेगा कि मेरा जो है काम मैं कम करूंगा और पैसे मुझे मिलेंगे.
Yeah,
सर जो शेयर्स है उनकी वैल्यू बढ़ेगी.
let's suppose he is 2 years old.
Sir, the minor will get exposure and representation by the firm.
Yes, but let's suppose the minor is hardly 5 years old. He has no sense about these businesses. Now the decision is being taken obviously by the guardian. He cannot take any such decision, prudent decision. Now the decision is being taken by the guardian. How would guardian think that the admission of minor into the firm is also beneficial for the minor? What could be the possible?
Sir, it could be for the security of the minor, to secure his future.
Yes, one possible answer. That since he has assets, he has some maybe he could be a minor and he is the son or daughter of a deceased person. He's an orphan, let's suppose. So the property and the assets of the partner of that orphan could be utilized. So it gonna be maximizing, multiplying his assets if they are invested into the businesses. ठीक है? That is one example. Number two यही है कि assets orphan के नाम पे नहीं है तो minor partner के नाम पे है. So obviously when that is invested into the firm, he will be getting some returns, or she will be getting some returns that will be adding to his or her existing uh, assets. So in some way, he will be benefiting as well, or he or she will be benefiting as well, while the firm would be getting benefit. So obviously, every time in the business um, contracts, there is a mutual give and take. So would be the case here. So property of the minor may be invested and profit earned. Partnership received some investment that could be used for partnership advantages. Obviously, उनके पास added capital आ गया है that could be further utilized for some other projects to expand the activities of the business, etc. ये सारा कुछ चलेगा. Minor may be admitted with the consent of all the partners for the benefit of the partnership. Now let's go to the other part of this subsection of section 30, which talks about the rights and duties of the partner. So such a minor has a right, number one, to share the property of the firm. Obviously, when he has invested, he or she has invested, so uh, they have the right to share the property of the firm. Whenever we will be talking about the property of the firm, property basically it belongs to the firm. It does not belong to the partnership. And when we say firm, it means all the partners. As against the concept in the company law, if you remember, in that case, it belongs to the property basically belongs to the company and not to the shareholders. But in partnership, the property belongs to the firm, and firm means all the partners collectively. So when he has become minor, becomes the partner, he becomes the giant giant owner of that property. So in this way, he's gonna share the property of the firm. To share profit as agreed upon. Number two, okay, number two, he has the right to share the profit in the firm. ये हमने पहले discuss कर लिया. He also has the right to have access, inspection, and copy of the accounts of all the activities of the firm. He can have access and he can inspect and the take copy of all the activity that is taking place in the firm. Now the next question is about his liability. What do you think? How would he be liable? He's getting the share in the property, he's getting the profit as agreed upon, and he has also the right to have inspection of all the documents of the firm. So what about his liability? Would he be liable unlimitedly as like other partners or otherwise?
Sir, he will not be liable.
सर
Why?
लिमिटेड लाइबिलिटी होगी सर.
सर ही विल नॉट बी द लायबल, मतलब उन तमाम कामों के लिए जो मतलब दूसरे पार्टनर्स ने किए होंगे, और उसकी लायबिलिटी जो है आई डोंट थिंक सो कि वो मतलब कि अनलिमिटेड होगी. उसके एसेट्स उसके साथ रिजर्व रहेंगे.
सर लिमिटेड लाइबिलिटी
सर
होगी
जैसे
सर.
कि सर ये
सर
जैसे कि फुल्ली पार्टनर नहीं है, अभी माइनर है, तो सर एडमिट किया गया है फॉर द बेनिफिट्स, तो सर ये इसकी लिमिटेड लायबिलिटी होगी।
Yes, but what happens in limited liability?
सर टू द एक्सटेंट ऑफ इस शेयर्स,
Yes,
सर जितना इसने शेयर वो दिया है सर उसके मुताबिक ही होगा,
whatever he
पर्सनली
has,
लायबल नहीं होगा।
yes. So whatever he has invested, his capital, his investment could be liable for the losses, but he would not be personally liable. While regarding the other partners, we know this concept that once you are a partner, if there is no agreement to the contrary, general rule is that you are not only your assets in the firm are liable, but your personal assets, other than that firm's asset, they are also liable. So my business that is being run in, let's suppose, Islamabad, that business is liable for any losses to the third party. And in addition to that, assets of the firm, my house, my property, my car, my all these things, they are also liable to pay back the debt if I am a partner. So ये जनरल रूल है तमाम पार्टनर्स का, बट व्हेन वी विल बी टॉकिंग अबाउट द माइनर पार्टनर, उसकी लाइबिलिटी जो है वो कंपनी वाले कॉन्सेप्ट की तरह होगी. Assets are liable, not personally liable. But another disadvantage is that he can't sue for accounts payment of his share in the property profit of the firm. He can't sue. In the previous lines, I told you he can have access to check the documents and the accounts of the firm, but he cannot sue the firm for his share in the property or profit. If he has not been paid the profit, he cannot sue the firm to get the profit. How do you see this provision? 029. Zero two nine. 032. 032. 033. Note them all. रशीद ठीक है ना, जिनको भी मैं नेम करूँ. 034.
Yes.
035. 036.
Yes, sir. Sir, ये question rephrase कर रहे हैं आप, sir.
I just said कि
Yes.
being a partner, he has a right to inspect the documents and the accounts of the firm, but his right to sue the firm for the purpose of profit or for the purpose of his property, that has been denied to him. He cannot do that. He cannot go to the court to get the profit of the firm.
Okay, sir.
Why?
Sir, because he is minor.
गार्डियन के जरिए तो सू हो सकता है. Nobody.
Sir, through guardian होगा.
गार्डियन के जरिए भी नहीं, can't do that. He can't do that even through guardian. Why?
Sir, इसके अलावा तो मेरे जहन में कुछ नहीं आ रहा है ऐसे.
ये
सर
क्लियर है.
बिकॉज
सर हो सकता है एग्रीमेंट की वजह
Section
से
30 provides that he can't sue for the profit and for share in the property. ये clear है. ठीक है. Previously you have seen he has been given the benefit of limited liability. ये advantage दे दिया गया. His assets are liable, he is not personally liable. So that was an advantage. Disadvantage accommodate करेंगे corresponding that he cannot sue the firm for the profit.
सर, तो ये तो एक बहुत बड़ा डिसएडवांटेज है. अगर उसको प्रॉफिट नहीं मिल रहा तो वो सू नहीं कर सकता. वो कहाँ से क्लेम करेगा? उसकी पास रेमेडी नहीं है कहीं कि वो कहीं से ले।
सर वो पार्टनर नहीं है तो सू नहीं कर सकता है सर।
अच्छा, what could be the possible answer? जरा सोचे इसमें for a minute कि he is not a he has been taken away this right, but if he is being given that right, if he has been given that right, what could be the possible scenario? किस सिचुएशन में अगर ये राइट इसको दे दिया जाता है तो किस सिनेरियो में दिया जा सकता है?
सर एक तो हमने ये पीछे पढ़ा था ना कि पार्टनरशिप में आप एक दूसरे को सू कर ही नहीं सकते जब तक वो डिसॉल्व ना हो।
Important thing is that he has limited liability, great advantage. Number two, I would say that he has not been altogether denied the right to sue, but a condition has been added. Something has been attached with that suit. Altogether denial नहीं है, लेकिन कुछ conditions add की गई है. What could be that possible condition?
सर वैसे माइनर सर इस केस में सर स्लीपिंग पार्टनर का रोल कर रहा है, फर्म में कोई कंट्रीब्यूशन नहीं कर रहा है। अगर वो कुछ कंट्रीब्यूशन करे या एक्टिव रहे तो फिर शायद वो लिमिटेड लायबल हो। सॉरी सर, फिर शायद वो सू कर सके।
Yes, but sleeping partner has a right to sue. If he is not being given the profit, he has a right. He has all the right like a partner, unless agreed upon.
यस सर, तो माइनर के केस में एक्सेप्शन है सर ये।
Yes, but my next question is, let's suppose partners agree to give him that right, लेकिन क्या वो कुछ conditions add करना चाहेंगे या conditions उन्हें कुछ add करनी चाहिए? Because they are giving him a very great advantage by making his liability limited. ये कोई कम advantage नहीं होता है।
यस, तो फिर
सर
लायबिलिटी
कंडीशन तो वो
इनको
करेंगे
करनी
ना,
होगी।
कंडीशन तो वो ऐड इसलिए करेंगे क्योंकि सेक्शन 30 उनको यहाँ तक वो कर रहा है कि आप बिल्कुल दे ही नहीं, यानी कि आप उसको सू करने का राइट बिल्कुल दे ही नहीं। तो वो अगर कंडीशन ऐड करे तो वो अपने बेनिफिट के लिए कंडीशन ऐड कर सकते हैं।
Yes, you're not getting my point.
सर जो हमने प्रीवियसली पढ़ा था सर कि अगर लिमिटेड लायबिलिटी के लिए फिर कंडीशन वो अप्लाई होगा अगर किसी पार्टनर को।
एक तो जैसे कि वो जालियां नहीं लगी हुई है थल्ले पर्दे में, एक तो जाली की तरफ हुई है, ठीक है, तो जालियां से बाहर भी मान से
ये कौन है? ये जाली क्या क्या? Who was this gentleman? अच्छा, section says that he can't sue, but he can sue, or he or she can sue when they are severing the connection with the firm. Once they decide to get away or to done away with the firm or to exclude from the firm or to exit from the firm, in that case they can sue. Generally, during the continuance of the firm, they cannot sue the firm during the continuance. But if they sue, they can sue only in that condition when they decide, when the minor or his guardian decide to sever or to exit the firm. If they are going to do that, in that case, automatically it becomes a suit of a civil nature. So there could be some problem. Automatically आप सिविल कोर्ट में जा सकते हैं, जो आपके राइट्स हैं एज ए सिविल लिटिगेंट वो एक्रू हो जाते हैं, and you can file a suit against the firm being a third party. Now you becoming a third party, you can file a suit that they have not paid me the profit for the last few years, or they have not returned me my assets or my property in the firm. ठीक है? But during the continuance of that firm, the minors are not entitled to sue the firm. इसकी क्या लॉजिक हो सकती है? If they want to get away, if they want to exit the firm, फिर उनको राइट दिया गया है, सेक्शन ही दे रहा है, लॉ दे रहा है.
सर वो
But
तो
during continuance of the firm, this right has been denied to them.
सर वो तो जनरली कोई भी नहीं कर सकता अगर कंटिन्यूएंस है, यानी कि फर्म में जब तक वो है, जब तक कि वो फर्म
कर सकते हैं, पार्टनर्स एक दूसरे को सू कर सकते हैं, ऐसे कोई नहीं. एक पार्टनर दूसरे पार्टनर को सू कर सकता है।